everybody. This is Dr. Perry Carpenter. I want to thank you for taking the time to join us on tonight's Zoominar. I have a fascinating Zoominar for you tonight, one of which I'm sure is going to be a tremendous learning experience for you as you prepare for and attend your very next deposition. And I'm assuming that if you're attending this Zoominar, whether you're an attorney or whether you're a qualified medical evaluator, you're attending this Zoominar in an effort or an attempt to learn some things, learn some tips, learn some secrets, learn some methods, learn some procedures that you can use so that you can be more comfortable, so that you can perform better, so that you can perform more confidently, so that you can perform more professionally, and so that you can once and for all feel good about yourself at deposition. And speaking from my own experience, and I probably speak for everyone in attendance here, if you're anything like me, you know, for the first 2 decades of my career as a qualified medical evaluator, depositions were something for me that were very stressful and were very distressful. And I'm sure many of you out there can relate to that. Well, after about my 200th deposition, I had a couple of aha moments and a couple of realizations that I began to incorporate into my preparation for deposition that allowed me to become more comfortable with deposition to the point where today I actually enjoy and look forward to depositions for the tremendous learning experience that they are. And depositions allow us to learn the perspective of our cases from the other side, from the side of the parties that we can learn in no other way. So depositions are a part and parcel of our career as qualified medical evaluator. And the purpose of tonight's session is to give you some insider's tips that you can incorporate into your very own next deposition so that you can begin to enjoy depositions as well. So I'm very, very excited to be here. I'm excited that you're here, and I know our guests are excited to be here as well. So that's J-Tech Medical. Thank you very much. I want to introduce our special guests tonight. We have 2 well-seasoned, well-respected, and venerable attorneys who have agreed to join us tonight. We have defense attorney Russell Ross, who's been doing defense work for over 4 decades. We have applicant attorney Ken Kingdon. Both are very well respected in their field. They're well known, they're well traveled, and they have a wealth of information to share with us tonight. So this is a rare treat for us. And so before we get started, if everyone would just give a virtual round of applause of thank you for our 2 guests tonight. Thank you very much for joining us. Okay, tonight's topics. So let's get started. We're going to move through some material very quickly. We want to touch on 3 major topic headings tonight. Number 1, want to go through the labor codes and codes of regulation that govern the deposition process. And this is a mandatory section imposed upon us by the Division of Workers' Compensation in order to qualify for the continuing education credits. So we'll share with you some of the labor codes that deal with the day-to-day operation of the deposition. Then we're going to go into a discussion of the most common reasons for depositions. Now, I know those of you that are doctors out in the audience, when you get a call or your secretary tells you that you received a call and the parties want 3 days for deposition, the first thing that goes through your mind is, why in the world are the parties calling me to deposition? This is what you wonder to yourself. Well, the attorneys are going to share with us the actual reasons why you're being called to deposition. I'm going to give you my speculated reasons, and the attorneys are going to give you the actual reasons why they call for doctors' depositions. And then we'll get into our final section as to how to prepare for deposition. And the attorneys are going to share with you in this section how they prepare to depose you at your upcoming deposition. So this is going to be a very valuable session for you. So let's begin with part number 1, the labor codes and codes of regulation. Mr. Ross?
Thank you, Dr. Carpenter, and thanks everybody for having us. CCR 10727 says that the Workers' Compensation Appeals Board favors cross-examination of medical witnesses by way of deposition. When I first read this regulation many, many years ago, I thought that we would still have the option in certain cases of being able to subpoena doctors to the appeals board and have them testify in front of a judge. And you can imagine the advantages that an attorney has in that setting. First of all, we take you out of the comfort zone of your own office, bring you down to an appeals board where you have to find a place to park and then wait in the waiting room until you get called as a witness like anyone else. But more importantly, if you were an applicant's attorney back then, you had the opportunity to elicit testimony that might help your case, especially if it involved treatment or temporary disability, and you could have the judge immediately issue an order to that effect so that there wouldn't be the delays in taking a deposition and then going to court and getting the supportive order. The second advantage, of course, was the judge controls the witness. So in cases where doctors wanted to be politicians instead of physicians, we were able to ask the judge to instruct the witness to answer the questions. That not only moved things along more smoothly, but it also got to the point that we wanted to achieve. Most importantly, after the doctor was deposed, we could bring in our own rebuttal witness. And oftentimes that would be an expert who would come in and comment as to what the doctor said and why his opinion wasn't correct. And you can imagine the impact that you would have on the judge if you were able to do that at the same time and place, rather than have him read a sterile deposition transcript and try to figure out what the parties were trying to do. Now, fortunately for you, and unfortunately for me, the appeals board has decided that the language which says it favors cross-examination of medical witnesses by way of deposition is really mandatory language. And I learned last night from Mr. Kingdon that he has yet to see in 30 years a cross-examination of a doctor in court. I have seen one in the last 30 years. So the appeals board is basically on your side in that regard. You don't have to go to court anymore to testify. I can't imagine a situation. I've tried many times with many presiding judges to try to convince them that the best way to handle this case would be to have the doctor testify in court, and they just won't allow it. So kudos to you and your lobby for getting that CCR enacted.
Okay, let's talk about fees. This is of importance to the doctors. So I was present during the fee schedule committee meetings wherein the fees for doctors' depositions were negotiated. So let's go over that regulation. This is found in CCR 9795. Most of you are probably familiar with this. It says that the physician shall be reimbursed at the rate of RV7. One RV is $16.25. So we get $113.75 per quarter hour, or each quarter hour rounded to the nearest quarter hour, for all itemized, reasonable, and necessary time related to the testimony, including reasonable preparation and travel time. Now, we're not doing as much travel time anymore because most seminars are done by, most depositions are done by Zoominar, by Zoom. But still, we get a minimum now of 2 hours for deposition. So if you do the math, 455 times 2 is $910 for the deposition. And this is pretty good pay. And this was negotiated during the fee schedule committee meetings when QMEs lobbied for what they referred to at the time as hazard pay. Hazard pay. This fee of $910, this generous fee, represents what the Division of Workers' Compensation considers to be hazard pay for depositions, because many qualified medical evaluators feel that it's hazardous or it's a high-risk situation to attend depositions. So this is a very generous fee for which we have great incentive to learn to perform well and to enjoy depositions. If a deposition is canceled fewer than 8 calendar days before the scheduled deposition, the physician shall be paid a minimum of 1 hour for the scheduled deposition. So typically with a canceled deposition, you will get to keep 1 hour of your prepayment of your $910 for the deposition. You can keep 1 hour. You retain 1 hour for credit towards your next rescheduled deposition. And then typically for the next rescheduled deposition, you'll ask the parties for another 1 hour. So you can see that for a rescheduled deposition, you could be getting as much as, what is that, 910 plus 455, 1365 for a rescheduled deposition, 910 for a kept deposition. So that's pretty good pay. Now, most doctors will demand, well, they'll request or softly demand, some doctors fully demand payment for deposition in advance of the deposition. But to my knowledge, and I'm going to go on record as saying that there is no regulation that compels the parties to pay in advance. It's my opinion, it's my experience that a prepayment in advance is a courtesy, but there's nothing in regulation that compels a payment in advance. But I think our guests will tell us, as what they've told me, is that the doctors have a pretty strong foundation for demanding this payment. And it seems to be customary in the industry that prepayment for a deposition is reasonable and customary. Okay, so that's payment. Let's talk about scheduling. Mr. Kingdon?
Yeah, the doctor is expected to schedule the deposition within 120 days. That seems reasonable. Even if the doctor's busy, that's still a lot of days. Plus, you'd think they could find 1 hour either before work, after work. If the doctor doesn't schedule it within 120 days, if there's a good reason, I'm sure the attorneys will allow that. If for some reason the doctor is not being cooperative and it's not clear why they wouldn't be, technically you could get rid of the doctor, replace the doctor with another QME. And the danger also for the doctor, if they still want to be in the system, is they could get reported to the administrative director. And I don't know if one incident's enough to lose your certification, but there are some penalties. On the other hand, if a doctor is supposed to do it within 120 days and sets it within 140 days, I think as a practical matter, it's a lot easier. Okay, we'll do it in 140 days rather than having to file petitions with the board and showing up and so on. So it shouldn't really be a problem.
Now, the next slide involves Labor Code Section 5710. This is just a reference to the general legal authority for setting depositions. It's controlled by the Code of Civil Procedure. Labor Code Section 5710 specifically applies to injured workers and the benefits that they're entitled to at the time of a deposition and how the deposition is performed. We have to pay reasonable expenses for transportation and meals and lodging to bring the applicant in for the deposition, especially if it's out of state, reimbursement for lost wages, provide a free copy of the transcript, etc. But the real reason that we discuss this is because all depositions, whether they're medical depositions or otherwise, are really controlled by the same Code of Civil Procedure. Now, the reference to CCP 2025.420 has to do with protective orders. And the reason that this is important, if you look at number B on the slide that's on the screen, the court, for any good cause shown, may make any order that justice requires to protect any party, deponent, or natural person or organization from unwarranted annoyance, embarrassment, or oppression, or undue burden and expense. And this protective order could include, but isn't limited to, the fact that the deposition might not be taken at all, or that it could be taken at a different time, or that a video recording of the deposition can be ordered. Now, the first thing I want to say about this is applicable in workers' compensation cases. It is the Code of Civil Procedure, but the Labor Code does not specifically deal with protective orders. So you look to the CCP to determine what law is applicable to these kinds of circumstances. I can tell you from personal experience that we had an attorney for many, many years down here in Southern California who prided himself on abusing doctors in depositions. And it was not uncommon for my firm to seek protective orders in those cases where he was going to depose a doctor because we knew he was going to be abusive, and that could cause real problems. Similarly, I've had experiences where I found an applicant's attorney badgering a doctor, repeatedly asking him over and over and over again the same question. Despite my objections that the question was asked and answered, the attorney continued the activity to the point where the doctor got very frustrated. It was obvious that he was having trouble even concentrating with this particular situation. I suggested to the doctor on the record that even though I didn't represent that doctor, he could seek a protective order if he felt he was being badgered. And of course, the applicant's attorney whined and screamed that he wasn't badgering the doctor, when in fact he was. Unfortunately, the doctor didn't listen to my recommendation, and in turn, he decided that he didn't want to be the AME anymore. And that was the wrong thing to do. That created a real problem for everybody because ostensibly, once the argument went before the board and I didn't handle that part of the case, the judge could have said, we're getting a replacement AME. And this was a very favorable defense opinion that the doctor had given, and that was the last thing in the world we wanted to happen. Now, I should also caution you that these are rare circumstances. We attorneys in the workers' compensation industry, and the reason I've loved it now for almost 50 years, is that we deal with each other on a regular basis. So there's civility involved in the representations and in the interactions that we have. We're going to see you again. We're going to see you again and again. And there's no reason to create ill will and bad feelings, unlike civil cases where the stakes are higher and the parties don't see each other as frequently. So normally depositions are civil. The parties comport themselves in their language. And I should also caution you that when it says annoyance, this is an equitable relief. And judges aren't going to look at this and say if the doctor is just ruffled because the attorney asked him a question that he didn't like, that's not a reason to seek a protective order. You have to have pretty outrageous conduct, I think, in order to go before the WCAB and request a protective order. Certainly, if you get an aggressive attorney who is disrespectful, who asks irrelevant questions, who wants to know personal information, and who repeatedly asks a question when the answer has been given over and over again, that kind of circumstance should allow for a motion before the board to secure a protective order. And that's my 2 cents.
Okay. So that's something we can, that will provide the doctors great comfort knowing that if they feel that they're getting badgered or harassed in any way, they do have relief through this protective order. It's not something that should happen, and there are remedies to employ even before getting to seeking a protective order, and we'll talk a little bit more about some of those. But this is a comfort for doctors to know that they don't have to withstand badgering and harassment at deposition. And that's Civil Code of Procedure 2025.420. Okay, let's talk about now the most common reasons for the deposition. I'll get my speculative reasons out on the table, and then we'll turn it over to the attorneys. And like you doctors in the audience, when I get a call for some dates for deposition, I always wonder to myself, why in the world are the parties asking me to come to deposition? Where was my report lacking? Where was it weak? What holes or gaps did I leave in my reasoning? And this whole this whole thought process goes through your mind. So over the years, I've come to realize that the reason that this is my opinion, this is speculative, this is my opinion and experience. The reason that the parties are calling for the doctor's deposition is because they need our help. They need our help to bring this case from second base to home base. The case is stuck somewhere in the infield between second and third base, and they're now going to enlist and recruit our help to bring the case to a successful resolution. So that's the purpose, is to move the case to a resolution. A deposition is an opportunity for all the parties to come together as a team, to get all on the same page as a team, to determine what are the outstanding issues and what needs to be done in order to move this case and claim forward. So to move the case closer to a resolution, to get the parties on the same page, to develop an action plan for bringing this case to a successful resolution. A deposition is an opportunity for the QME and for all parties to arrive at accuracy in the QME's opinions and conclusions, and to expose any inaccuracies so that those inaccuracies can be shored up. And then also to uncover or to develop any issues that have been neglected in the QME's report. And I speak with QMEs daily on a daily basis and help them prepare for depositions. And I let the QMEs know that depositions are a normal and natural process of the work that we do. Depositions are necessary to help bring cases to a successful resolution. So a deposition is not something that you need to be apprehensive about. It's not something that you need to stress over. The deposition is simply an opportunity for you to come together with the other parties in a spirit of cooperation and in a spirit of obtaining accuracy for the injured worker's case, to help bring the case, to help be an important team player on the team of bringing the case to a resolution. And so when I've recently adopted this as my modus operandi, it's helped me to relax and to participate with a clear head in the deposition, and actually to enjoy contributing to the successful resolution of the case. So that's my perception of my need and my participation in the deposition. Let's hear what the attorneys have to say.
I guess that's me. Yeah.
That's you.
All right, so I've got a list of items here. Some are guides issues, some are case law issues, and this is really why we take the deposition, and also hopefully it'll be somewhat informative to the listeners as to what the law is and how to approach this. So among the reasons for deposing the doctor, one is to change their mind. Maybe they reach one conclusion. I want to convince them that that's wrong for some reason. And also there are issues that the doctor didn't address. These are new issues. So one item that both sides are interested in is apportionment. As the applicant attorney, I want to decrease the apportionment, of course. One way to do that is to point out to the doctor that, you know, this MRI pre-injury, doctor, this didn't look that serious, and we see post-MRI is serious. Now maybe we have EMG NCVs that are positive. We didn't have that before, so maybe that'll influence the doctor. Sometimes reviewing the job analysis with the doctor helps. If it's an orthopedic surgeon, maybe the doctor gave a substantial amount of apportionment to a pre-existing problem, but I'll point out, doctor, according to this job analysis, this was a very arduous job. Did you consider that when you did your apportionment? Or doctor, the applicant worked at this job for 15 years. You know, did you consider that? So those are some of the factors that go into that. And another issue is what's known as the kite case. That's really shorthand for whether you add versus combine the ratings. And now the kite case dealt with bilateral hip injuries, and the word compensation was significant in kite. And when we say compensation, it didn't deal with money. The compensation issue in Kite was that the applicant injured one hip and he couldn't compensate by using his other hip by putting weight on that because that other hip was injured. So he couldn't compensate. That inability to compensate created a synergy, which justified it adding the ratings. So basically for applicant attorneys, anytime you see bilateral injuries, bilateral upper extremities, lower extremities, it's pretty close to the Kite situation, but there's a case called De Lacerda where the board is liberal and they said, well, you know, you don't really need synergy as long as it's more accurate. So really, they've moved this into the generic Alvarez-Guzman situation. You know, doctors can cite Alvarez-Guzman and say, well, I'm going to ignore the strict rating of the guides because it's not accurate. Here's why it's not accurate, and here's why this is more accurate. So those are the criteria that doctors have to follow if you're going to use Alvarez-Guzman. Now, there's one case law trend I wanted to bring up. It's interesting that from around 2014 until 2021, the WCAB, again being liberal, they would allow a doctor, say an orthopedist, to say, well, I'm going to add my orthopedic ratings to the ratings of the internist. And the board allowed that. There's almost every case I saw, they allowed that. What I noticed in 2022, I don't know, you know, what people started to think, but in most cases in 2022, they switched sides. What they said was, again, in multiple cases, if you're an orthopedist, you can't add your ratings to an internist. The internist can add the ratings to a psych and so on. So we'll see how that plays out in 2023. But that's the trend right now. None of those are definitive, but that's where the board, at least right now, seems to be going. Some other common issues that tend to come up in depositions. In the upper extremities chapter, you're not supposed to add range of motion, or you're not supposed to combine range of motion loss with strength loss. Again, the doctor can cite Alvarez-Guzman. You know, that's one way to get around that. Chapter 18, the pain chapter, limits the pain to 3%. You can cite Alvarez, and it's 3% for the whole injury. So a doctor can cite Alvarez-Guzman and say, well, I'm going to give 3% to the neck and to the knee because I think it's more accurate. There's more problems with ADLs. Another way doctors can get out of the 3% limit on headaches. Headaches is chapter 18. It's based on pain. The WCAB has indicated in case law, if a doctor wants to analogize headaches to chapter 13, the trigeminal nerve table, and go beyond the 3%, as long as the doctor provides a reasonable explanation for it, they'll allow it. Another issue that's fairly heavily litigated, and there are people on both sides of the issue. If you look on page 380 of the guides, it says that if you have multi-level involvement or bilateral involvement, you can use the range of motion method, and not the DRE method. And of course, the ROM method rates higher. And so there's a dispute there between when they say multi-level involvement, do they mean multi-level or bilateral radiculopathy, or do they mean pathology? And the doctors go both ways, judges go both ways, so there's no definitive answer on this. If you're an applicant attorney, if you read what it says on page 380, if you read it literally, it looks like they put an extra comma in there, which is why applicants have a good argument that, well, as long as you have multi-level degeneration or pathology, then you're in the ROM method. So that's a dispute on that, and that's a subject for deposition. Although, again, when we look at something like that, arguably it's actually a judge's decision. You know, if a doctor says someone needs surgery, someone needs medication, someone needs treatment, this is future medical, those are medical issues, that's for the doctor. When we come into an issue like this, pathology versus radiculopathy, arguably that's really ultimately for the judge to interpret the language in the guides, although of course judges look to doctors, for guidance as well. One thing that you want to avoid as a doctor, you don't want to rewrite the guides. So what I mean is, if you're going to use Alvarez-Guzman, you have to explain why the strict rating does not apply to this applicant. An example was, there was a case where the doctor says, I don't like the way the guides rates grip loss, so I'm not going to use their tables. All right. That was rejected. All right. That's rewriting the guides. If the doctor had said, well, in this case, grip loss doesn't accurately reflect the applicant's problems with ADLs. He's got the following ADLs, then it would have been accepted. Another thing that could be helpful to applicants is to establish the doctor's credibility. Now, the judge is the ultimate decider of credibility, but again, judges will look to doctors, all right? And so it's important. For example, if there's a question about mechanism of injury, the applicant says he fell, nobody witnessed it, or the applicant's claiming moderate to severe pain, and we don't think so, and we have films and so on. So you've got these credibility issues, and if the applicant is deemed credible, it certainly helps their case. Sometimes actually, with an orthopedist, you might say, doctor, you want to refer the applicant to a psychiatrist to see if there's a psychiatric overlay or to determine the credibility, and sometimes the doctor will go with that. Another issue that comes up is the Benson case. So if you have, let's say you hurt your back and there are two specific dates of injury, if you can combine them, we have a progressive rating system, so that's better for the applicant. Benson says they're rated separately. But of course, in the Benson case, it says, well, there are exceptions, and it doesn't say inextricably intertwined in the case, but that's a phrase that's become accepted by the board. So again, if you feel as the doctor that you can't apportion between the CT and the specific or between two specific injuries, the phrase is, well, they're inextricably intertwined. Now that's conclusory. You have to explain why you can't distinguish them. Otherwise, your conclusions may be rejected. Another issue is DRE category 2 versus 3. Could be a fine line. Maybe you've got an EMG and maybe it shows up, maybe it's positive. Well, a positive EMG could only be radiculitis, which is inflammation of the nerve root, and maybe that doesn't get you into the DRE3, which is radiculopathy. Now, radiculopathy in the guides, page 382, they define it as alteration in the function of the nerve root. Now, what does that mean? All right, so one example or examples of radiculopathy listed in the DRE tables. If there's sensory loss, which is usually numbness, motor loss, which is strength loss, pain. Now, those are subjective, all right, but doctors evaluate subjective complaints frequently. Now, objective findings are pretty strong evidence. Reflex loss, atrophy. So if you have that, you're pretty clearly going to be a DRE3 radiculopathy. Now, also, again, you have this borderline DRE2, DRE3. Sometimes the doctor rates DRE3 and his conclusion says it's merely a sprain. Sometimes the conclusion says radiculopathy and the doctor rates DRE2. So those are the borderline questions. If you have that at depositions, a lot of times, I'll ask the doctor, all right, doctor, we're kind of in a gray area. Do you think an MRI and an EMG NCV would help you? So, and usually they'll agree with that because it does help them to get a clear picture of what's going on. And another major reason for deposing doctors is if you're the orthopedist, we're going to ask you, well, doctor, looks like there's some hypertension here, looks like there's a psych problem. And so we rely on you as the orthopedist to make referrals to these other specialties. And some doctors, for various reasons, decide, well, I'm going to address everything. So you might ask the orthopedist, doctor, do you think that this should be sent to an internist because, we've got hypertension readings, systolic as well as diastolic, and the doctor says, no, I don't think so. I don't think, he's got hypertension. Well, generally, if before I ask that, I point out to the doctor, there's a regulation 41, and the title is Ethical Requirements. And if you read 41C4, which I'll bring to the doctor's attention, it says a doctor can render an opinion only on issues on which they have the qualifications, education, training, and specialty-based knowledge. So if a doctor is an ortho, he says, no, I don't think he has a psych problem. You know, they're outside of their expertise, and they could be violating the ethical requirements of Regulation 41. You know, and then finally, one reason, of course, to take the doctor's deposition, the doctor may have just overlooked the body part or an issue. So, you know, sometimes that requires a deposition. So those are some of the reasons.
That's a lot. That's a lot to think about.
You know, Mr. Kingdon talked about reasons to take depositions, and every reason was a legal reason. And that's why defendants take depositions. Defendants take depositions to address deficiencies in the medical legal issues of the case, issues regarding causation, issues regarding temporary disability, as discussed, issues regarding whole person impairment, future medical care, and apportionment. Apportionment's a big deal for the defendants. It's a part of almost every deposition we take. Now, the reason that I'm here, Dr. Carpenter gave a program on depositions that I viewed, and he told a story about an applicant's attorney who he discussed after a deposition, which seemed to be kind of meaningless. He asked the applicant's attorney, can you give me some reasons why a defense attorney would set a deposition? And the applicant's attorney provided 10 reasons to Dr. Carpenter as to why defendants take depositions. The first reason was to increase billing for his firm so that he could make more money. I don't know if that was facetious or just ignorant, but Dr. Carpenter advised that that's a common misconception out there. The doctors think that depositions are taken for billing purposes. Let me explain to you something that you may not know. Defense attorneys bill in increments of 1/10 of an hour. That's 6 minutes. Every time we review a piece of correspondence, every time we make a quick phone call, every time we zip off an email, it's a minimum of 1/10 of an hour. It's not unusual for a defense attorney to sit in his office for a couple of hours when he's not disturbed, go through stacks of mail, and in 2 hours bill 6-7 hours of billable time. That's where defense attorneys make their money. Where the breaks come in and where we lose money is when we attend timed events like a deposition. If you think about it, the first page of the transcript says deposition start time 10:01. The last page of the transcript says deposition ends at 10:31. That's a half an hour. That's what you can bill to your client. It's obviously verifiable. So defense attorneys don't like to take depositions for billing purposes, period. We don't even like to make appearances for billing purposes because it's the same concept. We can make a lot more money sitting in the office and grinding through mail and making phone calls than we can taking depositions. And the concept and thought that we're setting depositions to make money is just wrong. And it's never been right. So disabuse yourself of that thought. That's not what's happening. Now, another reason defendants take depositions, and this may not be readily apparent, is that we want to make sure to the greatest extent appropriate that borderline pension cases are justified. And what I mean by that is this. We've got the rating in the case from your report. Maybe it's a chiropractic or an orthopedic report or an internal report, but there's also possibly other body parts in the case. And if the overall rating after adjustment for age and occupation comes out to be 70 or 71 or 72%, that is substantially different than 69%. The jump in the rating points from 69 to 70 is thousands of dollars. Plus, after 70%, the applicant gets a pension for every percentage point over 70%. Now, that's a lot of money to have an insurance company or an employer pick up. And so it has to be looked at carefully. You have to make sure that you overturned all of the stones of investigation in order to make sure that that rating is appropriate. And believe me, if I can come in and establish the fact that the applicant's body mass index is 34.5, he's 5'4", he weighs 260 pounds, he's got knee problems, and I can get 10% apportionment to obesity, that may be it. That may be all I need to drop the matter down from 70 to 69. And sometimes the doctor will look at me after the deposition and said, you took all this time for the deposition. Why did you do it? The rating. It was all about the rating. So that happens more times than you might think. And again, you may not even be aware of what's going on because you don't get all the medical and you don't have all the ratings for all the body parts. But that's one of the primary reasons why we take depositions. We also take depositions when we're looking at cases of close to total disability. Same reason, lots of money at stake. We have to make sure that we're saddling the insurance carrier or the self-insured employer with the amount of money that's appropriate and not a windfall to the applicant. And again, as I said earlier, apportionment is always an issue. We take a lot of depositions regarding apportionment, and that's something you need to know. So as far as the reasons why we take depos, those are a couple of reasons why we take them, and one big reason why we don't.
Okay, so let's talk about how to prepare for deposition from the QME perspective. This is a sequence of events that I go through, and I suggest there might be a couple of ideas for you here as well. Of course, you're going to want to review your chart for accuracy and inaccuracy, and I put a couple of asterisks here next to inaccuracy, so I'll come back to that in just a moment. The second thing that I do when I'm called to deposition and I review the chart is I ask myself, under what labor code was the evaluation for which I'm being deposed, for which my report relates to? What labor code was the evaluation ordered under? Was it ordered under Labor Code 4060? Was it ordered under 4061, or was it ordered under 4062? If you know the issue for which your evaluation was ordered, you know how to prepare for the deposition. So if the evaluation was ordered under Labor Code 4060, you know that you were dealing with a compensability evaluation. And the issue at deposition is going to be a compensability issue. It'll be whether your opinion was for or against industrial causation, and it may relate to your opinion related to additional body parts as well. If the evaluation was ordered under Labor Code 4061, then you know you're dealing with a dispute over your permanent impairment formulation, and you better shore up your permanent impairment formulation, and you better bone up and be familiar with how you arrived at your permanent impairment formulation. If the evaluation was ordered under Labor Code 4062, and you can get this. You can get this information by asking for QME Form 106 upon the initial appointment call. When your office receives that first appointment call, ask for a copy of QME Form 106, and it'll tell you on QME Form 106 under which of these labor codes the evaluation was ordered. We do that on every single case that we take in here. If the evaluation was ordered under Labor Code 4062, you know your permanent and stationary argument is the relevant argument. There may be some dispute as to your approximate percentages. Work status and temporary disability are also covered under 4062. And regardless of which labor code the evaluation was ordered under, regardless, whatever your opinions and conclusions are, you want to always ask yourself, are my opinions and conclusions substantial? Do they qualify as substantial medical evidence? Did I provide a good how and why reasoning in support of each and every one of my opinions and conclusions? If you can confirm that your opinions and conclusions qualify as substantial, you can do no better as a qualified medical evaluator. That is the highest ideal that you can aspire to with your opinions and conclusions, is to qualify each and every one of them as substantial medical evidence. So go through each and every one of your opinions and conclusions and ask yourself, where will the attorneys find my opinion insubstantial? So that's that. And then I wanted to come back here to this concept of accuracy and inaccuracy. If you're reviewing your chart and you're reporting before you get to the deposition, and you yourself discover some inaccuracy, it's probably a good likelihood that the other parties have also discovered the inaccuracy, and that inaccuracy is going to be fodder for interrogation at the deposition. If you discover an inaccuracy, I suggest that you raise the inaccuracy yourself at the beginning of the deposition and show your cards and open it up for discussion. And this goes back to our philosophy as to the need for deposition. The need for the deposition is for all the parties to get on the same page so that the case can be brought in to a successful resolution. So if you have an inaccuracy, explain it to the parties at the beginning of the deposition, and that may change the whole tone and the whole direction of the deposition, and it may create a new direction for you and for the parties, and a new touch on the case. It may create a need for a supplemental report, may create a need for a new face-to-face evaluation, all of which is intended to help bring the case to a successful resolution. So those are my suggestions. Attorney Kingdon, how do you prepare?
Okay, well, the first issue here, I look at whether the report is favorable or not towards the applicant. And, occasionally there's a doctor that's got a certain bias towards the defense. And of course, I prepared differently for that type of deposition than I would if I felt there was a neutral AME, for example, on the case. But in situations like that, I found that I really need to give the doctor the benefit of the doubt, because I've had reports where it looks like, wow, this guy gave a 0 after knee surgery or back surgery. I mean, what's this guy thinking? But before I really maybe get a little confrontational, I'll just ask him some, regular questions that I would ask any doctor. And a lot of times it turns out that the doctor is not biased. Maybe he didn't know, maybe he's not that familiar with the guides, maybe he made a mistake, maybe overlooked something. So, and I also, of course, I go online to look up the doctor, and sometimes you look on Yelp, and if you see 15 comments from applicants about, this doctor really was hostile to me, whatever, that kind of gives you a sense also. So, but I try to keep an open mind on that. And of course, I looked at the doctor's conclusions. Is it consistent with the guides? Is it consistent with case law? So I know that's an issue I'm going to have to raise at the deposition. Now, this next issue about the medical record, that's important. I find that can be really time consuming, but it's something that I often have to do. Sometimes a doctor will say, well, maybe the applicant got injured in 2020 and the doctor, there's 15 pages of medical records, and the doctor says, well, there's no evidence that the applicant treated for his lumbar spine after the injury. So I have to read through all these records, and, I find in 2021, there's a report the applicant was treating with an orthopedist who indicated that there's radiating pain into the left lower extremity or whatever. So a lot of times I find items in the record that the doctor may have overlooked. Another item that I see a few times is if the applicant has a distal clavicle resection, also known as a Mumford procedure. According to the guides, that's a standard 6% for that type of surgery, as opposed to other types of shoulder surgeries. And according to the guides, that 6% is combined with a loss of range of motion. And it's not that unusual for doctors in a complex case with a lot of records to overlook that this particular surgery was the Mumford procedure. Also, I want to speak to the applicant before the deposition to know, has your condition changed? Are you worse? Are you seeing an internist? Are you taking more pain medication? So I can bring that to the doctor's attention, which could change the doctor's conclusion. Maybe the doctor will then want to reevaluate the applicant. And that's the next point. Same thing. Is there new information from the applicant or from some other doctor. And then will further testing be required? I've had situations where the applicant worked in a factory for 10 years and it reports some knee pain, and the doctor says, yeah, there's a little bit of pain, but I'm going to rate the knee at 0. And you say to the doctor, the deposition, well, doctor, 10 years of arduous work, the applicant's 50 years old. Do you think it's reasonable that we get bilateral standing x-rays of the knees to see if there's arthritis in the knees, which is a rateable impairment under the guide? So that's an issue to address. So those are some of the issues that I'll prepare with.
Should I go quick?
Do your job.
All right, so I prepare for a deposition pretty much the same way every time. I review the medical, and then I review the entire file, and then I sleep on it. And usually inspiration comes to me in the form of issues. I try to figure out where I'm going with the deposition and how I'm going to develop the answers that I want to hear. I look to medical and legal research if necessary in order to make sure I know what I'm talking about. I don't pretend to be a doctor. I don't want to be a doctor in that setting, but don't think that I am totally ignorant of physiology and medical terms that have meaning not only to you, but to me and to the AMA guides. So I try to get prepared as best I can by going through the medical issues, the medical legal issues that we talked about, and try to formulate a game plan. Now, in the old days when we used to develop testimony in court, things were usually pretty rushed. The judge wanted to get to the point. The judge didn't want you to do a lot of foundational work. I've changed over the years. I do a lot of foundational work. I try to get as much information as I can. As Ken says, you try to get in the doctor's head a little bit, find out where they're coming from. Who knows? Sometimes the doctors don't agree with the fact that a continuous trauma injury is recognized as an injury by the WCAB. There are some doctors that just don't buy it from a medical standpoint. Other doctors, will say things like, in their personal opinion, if it's a cancer case, then it's compensable, regardless of the fact that there could be 4 or 5 other causes that contributed or actually caused the disability. So again, review the file. I look at it. I try to get as much information as I can. Information is king in our business, and I try to present the best argument I can to try to reach the result that I think is appropriate.
Very good. Okay, we're going to conclude the PowerPoint presentation and go to questions and answers. I know that's a lot of information there, and I'm sure there's a lot of questions along the way. So let's go to the questions and answers. Okay, we have one here. Okay, so this is for Mr. Kingdon. Says Dr. Rapoff asked, perhaps the periods of TTD better known by someone. Oh, for example, so on your reasons for requesting a deposition, you said that one of the reasons that you would call for a deposition is because to clarify the periods of temporary total disability. So Attorney Rapoff, Dr. Rapoff asks, with regards to periods of total temporary disability, isn't that something that's better ascertained by someone besides the qualified medical evaluator? In other words, isn't that information that's better known by, say, the claims administrator who's paid those periods of temporary disability?
Well, the administrator is paying for it, but the question is, what period of time should they be paying for? So some of it turns on. The doctor might say in his report, the applicant can return to modified work, and he tries to go back to work, and there's no modified work available, so he can't work. So he's entitled to temporary disability. So it's really it depends on the doctor's conclusions. He might say, okay, I'm releasing the applicant to full duty, well, then obviously temporary disability ceases at that point.
Okay, so what do you expect from the qualified medical evaluator with regards to his discussion of the periods of total temporary disability?
Well, sometimes it becomes an issue because the doctor didn't address it or, again, didn't understand. They might say, well, the applicant, the doctor might say the applicant, well, let's say he says the applicant has reached MMI on June 2nd, 2022 or something, and I'll point out to the doctor, this is a different issue, point out to the doctor, well, you haven't seen the applicant since, for 12 months, but he's been seeing Dr. Jones. Dr. Jones has taken him off work. His pain levels increased. He's getting physical therapy. He's getting epidural injections. And at that point, maybe the doctor has to do a reevaluation to determine the actual MMI date or whether he's still TTD. So a lot of factors that go into it.
There's also a question of temporary partial disability, and maybe that needs to be clarified because those are periods where we're not paying temporary disability, but the applicant is not MMI and is still in need of treatment. So sometimes the QME who's seeing the case last is in the best position to be able to either decrease the TD claim or increase it.
Say that again.
Sometimes the QME could be the last person who's seeing the applicant on the treatment scale. And he's arguably got all the medical, all of the history, all of the complaints, and he may be in the best position, he or she may be in the best position to make the determination as to whether the temporary disability that was paid was too much or not enough.
Okay. I can see that could put the QME in a bit of an awkward position if the opinion was that the TD was too much.
Well, that's my argument.
Okay. I have a question here. I believe this is from one of the attorneys in the audience, and of course, this is a fabulous question. He says that so far we have given no time or attention to the issue of having the doctors review both parties' advocacy letters, when in fact the doctor's failure to address all issues in the report is one reason why the deposition is set in the first place. Very interesting and well-known issue.
If we had another couple of hours to make this presentation, that would have been probably the first thing that I would have talked about. Because if a doctor wants to know why the deposition is being set, first thing they should do is read the joint letter or the advocacy letters that will probably raise the issues for them. And then when they look at their report, if they didn't adequately address those issues, then they know what's coming. So, for example, as we discussed, if the medical that's provided to the doctor shows a prior award for disability, including the AME report that substantiated the stipulated award and the judge's order, you got to figure Labor Code 4664 is going to be an issue, and it's going to be something that's going to be discussed in terms of overlap. So that's a red flag, and that's something that obviously you need to do.
And, the Labor Code says the doctor is supposed to address all issues raised by the parties. If he doesn't, what's your options? Again, maybe take his deposition, send him a letter, So there's not that much you can do about it, really, practically.
So I have a comment from Mr. Timmons, and that is with regards to the cover letters. So much has been said about QMEs addressing the questions in the attorney cover letters, and we know that this is a big deficiency in QME reporting. One thing that came up just the other day in the DWC's report quality committee meetings was that that QMEs could do a much better job with their reporting if they understood better your needs and what you need from QMEs in their reporting. Many QMEs don't understand what goes on in your world because they've never been to court, they've never been in front of the judge. They've never engaged in settlement negotiations. QMEs have no knowledge at all of what applicant and defense attorneys go through. And so if they better understood your needs, they could do better. And so one suggestion that came up at the report quality committee meetings was kind of an analogy to QME reports, where in QME reports, you ask the QME, what are the reasons? What are the reasons for your conclusion? Well, what the report quality committee stumbled upon was it would be good if the attorneys could provide the reasons for the question in your cover letters so that the QMEs could better understand the reason why you need this particular answer. So I think getting better quality reports from QMEs has to be partly the responsibility of better cover letters as well on the part of the attorneys. And I hope not to offend anybody, because we know that the QMEs need to do a much, much better job. But what I'm saying is if the QMEs understood better what you need from them, they could do a better job at giving you what you actually need. That's my comment on that.
Information is king.
Information is king. And then last question, and then we'll call it for a night. And I understand we're having some trouble with the chat, so I'll address that after the final question here. This is for both Mr. Kingdon and Mr. Ross. Do you foresee a day when the depositions will go back to live face-to-face depositions?
I hope so.
I'm sorry, I can comment on that. Actually, even before COVID and before Zoom, for applicant clients, I would show up at the deposition and intuitively you think, oh, it's really important to be there. You look the guy in the eye and so on. And I noticed that sometimes the defense attorney wouldn't show up. They would just phone it in, you know, so the attorney would be asking their questions through the telephone. And I noticed that it made no difference. So I actually stopped showing up myself. So again, before Zoom, I started doing depositions by phone. And again, I don't think it made a difference. And now we have Zoom. And so at least from my perspective, I don't see a point in showing up. I don't see, to me, for my clients, I don't think it's necessary. But I don't know, Russ, maybe, you know, your clients see it differently.
Well, and I see it differently. I mean, I disagree that, the face-to-face contact isn't important. If the doctors want to know what we're going to ask them, usually that conversation occurs before the deposition. You can't do that in a Zoom setting. When you're meeting the doctor and you're in his waiting room for 15 minutes before the depo starts, oftentimes they'll come out and say, what's going on? Can we talk about this? You don't want to have an ex-parte conversation, but by the time the other side gets there and you have a few minutes to discuss it, you usually have an opportunity to go over the roadway and the groundwork and give the doctor an idea of where you're going in the case. And that happens a lot. And I'm sure you did that in the past before you stopped appearing at the depositions. I've never phoned in a deposition when there was an in-person opportunity to be there, ever. I always take the opportunity to have the in-person setting, and if it could go back to taking the doctor to court, I'd love that too.
Try phoning it in.
Is there anything on the horizon that would compel face-to-face depositions versus the Zoom depositions that we now enjoy?
No.
No, and I would say,
not that I know of.
Yeah, even before Zoom, it wasn't required. So why would it be required now?
No, it's not. It's not going to happen. It's a pipe dream for me. But I do take advantage of the Zoom, and if we do have in-person depots, I just set a depot today of an AME in orthopedics out in on the Inland Empire, and I asked the receptionist if we could do an in-person, and he said, no, doctor doesn't allow those. So, I'm sure that's the predominant feeling of most physicians. They really don't. They don't want me in their office any more than my picture on a screen asking them some questions.
Okay, on that note, and if there's no further questions in the chat or the Q&A, I think we'll conclude on this. I want to thank our guests for joining us. It's a sincere pleasure to have gotten to know you over the last couple of practice sessions, and it's a treat for us as qualified medical evaluators to be able to learn from your experience. So on behalf of the whole audience, I want to thank you again for your assistance tonight.
Thank you for having us.
Wish everybody a good evening, and I look forward to our very next Zoominar together. Have a good night, everybody.
All right,
Thank you.
All right, bye now.
Thank you.
Thank you.